if you ever find yourself talking to a council officer and they're trying to tell you that they can't follow the law because they don't have enough resources, not enough staffing, there's not enough money, there's not enough housing, all the rest of it, then that officer either doesn't understand the nature of a legal duty or they're just basically lying to your face. And the reason I'm making a video about this at the moment is I've just been going through some more LGSCO cases, looking at different cases which are important and useful to learn from. And I came across this case involving Hillingdon Council. And in this case, there was this household. One of the children had some significant mobility issues, some kind of disability, I'm not quite sure what. And Hillingdon Council had placed them in accommodation which was not suitable for that particular child's needs. And the family complained, quite rightly so. And in the course of the LGSCO investigation, I'm guessing that Hillingdon Council tried to excuse their failure by saying, this was the best we had. And in the final report, the LGSCO said, and I'll quote, "The fact that there was nothing better available does not make the accommodation offered suitable." And this is something which you see not just in suitability issues, but in a whole host of duties that are under the Housing Act, where councils kind of say, well, this is the best we can do, even though they know it's not actually good enough to actually meet the legal duty for whatever reason. And so that made me think of another really important case called Imam v Croydon, which is a Supreme Court case from, I think, 2023. It was kind of finally published. It involved a lady called Miss Imam who had some physical disabilities. She made a homes application to Croydon many years ago, and in 2014 they accepted the main housing duty and placed her and her family into accommodation which had some adaptations made to it, but they weren't enough to meet all of the needs that she had because she had some quite specific kind of disabilities. And it seems that Croydon from day one basically said, look, we know this isn't suitable, but right now it's the best we have. We haven't got enough housing, there's loads of people above you in the list, there's nothing we can do other than let you wait. And several years into this process, I think 4 or 5 years into it, the family basically pursue legal proceedings against the council, trying to get a mandatory order to make the council comply with its legal duty. So a mandatory order is literally when a court says, go do it, you've got to do it, and if you don't, there's some very serious consequences. I think there might even be kind of the risk of imprisonment, but I don't know too much about that. And so Croydon's defence was, we are absolutely strapped for cash, and as councils go, they absolutely were. And they cited an old case from the 19th century involving a limited company which had a duty for some reason to build a bridge over a railway. Don't ask me about the background of that case. And in that situation, the company was going bankrupt. If it was not already kind of defunct, it was on the way to being so. And in the case, the court basically said, there's no point putting a mandatory order here because they can't comply. There's literally no way they can comply, that the company's just done. And Croydon used this case to say, well, you know what, we're also pretty stuck for cash, therefore we don't have the capacity to do this stuff, therefore, let us off, judge, sort of thing. And there was then a long discussion in a case which basically was talking about if the judge was to allow that, then what they were in effect doing was to say for any council with any duty, it was to make these duties basically discretionary, so make them a power rather than a duty. And I guess just to use that bit of jargon there, councils have duties, councils have powers, they're two different things. In the homes application, as an example, in that process, most of the things councils have to do are duties. So accept an application, provide interim accommodation, make a decision within a timely, in a timely fashion, that kind of stuff. They're all duties, relief duty and so on. And there are a few things which are powers. So for example, if you challenge a Section 184 decision and you ask to be housed, then there is a power for the council to house you whilst the review takes place, but it's not a duty. Now there is some case law actually in that case which would basically say when the council should exercise its power. It's almost as good as a duty, but not quite, I guess. But that was basically what was at stake in this case. If Croydon won it, then councils across the country could basically say, whoa, we haven't got any money, we're just going to treat these duties as powers and we'll follow the law when we feel like it. And the judge basically, fortunately, said, nah, that's not all right. And if I quote a few bits from it, just to kind of give you a bit of a picture, as I say, it's worth reading the whole thing actually. It's about 20 or 30 pages, I think. So in this paragraph here, so in this section, Lord Justice Lewis said that constraints on resources are not a reason for not complying with a duty imposed by Parliament. So the Housing Act is imposed by Parliament. And it goes on to say that when it comes to providing suitable accommodation, and this wouldn't just be about main duty, but it would also apply to interim accommodation and so on, that the duty owed is immediate, non-deferrable and unqualified. Now bear in mind that Croydon had taken like 5 or 6 years by this point to even kind of get this far. really what they're talking about here is if you literally had nothing suitable available on the day, then you need to find the most suitable thing you possibly can do. And then it kind of talks about in the time frame of a few more days should be, what's required to provide suitable accommodation to that household, rather than 5 or 6 years, as I say. The judge kind of went to explore a few more things and said some other really useful and interesting bits as well. So for example, here it says, the reason Croydon may not have resources immediately available to comply with a mandatory order will reflect choices it has made in the past regarding its use of general resources. And if it does not have suitable accommodation immediately available, why should it not be expected simply to call on its general resources, perhaps by borrowing money, to adapt an existing property or to rent or buy a suitable property without delay to add to its stock of immediately available resources and comply with the order in that way? So, really good question. This is part of a kind of really interesting exploration of councils' functions in general, because, as I say, councils have lots of duties in different areas of law, which are non-negotiable. And also councils spend a lot of money on things which aren't duties and potentially aren't even powers. So I'll give an example. I live in Bedford, or near Bedford, and Bedford's got some very nice public spaces, really nice flower beds and so on. As far as I know, there is no duty to have really nice flower beds, nice though it certainly is. And therefore, Bedford Borough Council is potentially making political choices where they are choosing to spend their money on not having nice flower beds, which I'd imagine cost hundreds of thousands of pounds every year, versus potentially discharging their duties lawfully under the Housing Act. I'm sure the same would go for Croydon. There's going to be lots of things that Croydon do which aren't actually part of or under a legal duty. And here it's basically, here the judge is kind of saying, they made a choice at some point in the past that has led them to this point now when they don't have enough resources to discharge their duties. And so when I see housing officers unlawfully denying someone suitable housing, in whichever way they happen to do it, they're not fixing anything. What they're really doing is they're taking that council one step further away from being able to be resourced to discharge their duties lawfully. Gatekeeping is a good example of this. When people get gate kept, they don't cease to exist. There's still, there's still a problem there. But by gatekeeping, the council is essentially underreporting the level of homelessness that is really happening and essentially how much resources they really need. So when it comes to a budget review and the kind of central government looks at their stats and says, okay, you only got half the number of people you're really reporting, we're going to give you half the money you actually need. And so it becomes this kind of self-perpetuating issue where councils just get themselves deeper and deeper into trouble because they haven't done the right thing over the course of many years. And a lot of those decisions will be done politically. So every council has an elected membership. In Bedford, as an example, I think we've got about 40 councillors plus a mayor, and they make decisions on kind of anything that's kind of like important like this. And obviously councillors like to be popular, so they're going to want to put money into things like having nice flower beds in public spaces, and then potentially going to be able to get away with not resourcing the housing team properly and making sure there's enough housing and all that kind of stuff. Because as I say, if they think they can get away with it, if no one notices, homeless people aren't very well positioned to advocate for themselves in that situation. They're going to go for things which are going to be more popular. And so that kind of raises this issue of, if you are a citizen of this country and you haven't been down to a local council meeting of some kind to raise an issue which you're bothered about, then if nothing else you're missing an absolute trick, and effectively you're just allowing your council to get away with more and more bad stuff basically. If I was a Croydon resident, I'd be embarrassed that my council was doing this sort of stuff. I'd want to be there holding them to account over the course of many years so they actually know what they need to know when they're making these kinds of financial decisions. And so this question came back to Croydon about what are they going to do about it. And I think it ultimately did result in a mandatory order being imposed on them, but I think it had to go back to the High Court to do that. Don't ask me why, no idea. But the judge also said that Croydon can, if it wishes, divert money from other functions which are merely discretionary, so as to apply such diverted monies to discharge statutory duties. The argument is not one of sufficient resources to discharge the duty, but on a preference for using the money for other purposes. To permit a local authority to avoid performing a statutory duty on the grounds that it prefers to spend the money in other ways is to downgrade a statutory duty to a discretionary power. So that's an incredibly cool paragraph that the judge has written there. And again, in this case, in effect, Croydon were going to be expected, I would imagine, to use some money from somewhere, doesn't matter where, as long as it's not money that's going to be used for another legal duty. They have to find some money somewhere to buy, build, rent, do whatever they need to do to make suitable accommodation for this family. And part of Croydon's argument against this was that if they were going to have to do it for Miss Imam, then they're going to have to do it for all the other people who are in a worse situation than Miss Imam, because there was certainly talk of about 16 families who are above her on the list in terms of her banding. And the judge doesn't actually say it, but the way the judge talks about it and the logic they use would suggest that in actual fact the answer to that question is, yeah, you not only have to house Miss Imam right now in suitable accommodation, but you need to go and find these other families which are also in the same or similar situations and house them as well. So you can see that's an incredibly onerous duty on the council, but that's the nature of these duties. That is why Parliament set it out this way, was to make sure this kind of service, this kind of protection against the very worst things about homelessness and kind of unsuitable accommodation would not be allowed to just kind of rest on the most vulnerable people in society. So it's not accidental that this is how it is. This is MPs over the course of decades trying to enact the will of the people, and effectively what the MPs are saying is, this is what Britain wants. Britain wants to have a working safety net where councils don't get to spend money on non-essential things and not discharge their duties lawfully to vulnerable people in various circumstances. So I'm hoping that's useful. As I say, there's a lot of miserable cases happening right now, or certainly ones which seem to be kind of chipping away at the power that the law has. This was a really kind of welcome one. I'm sure the lawyers involved in this case were like losing sleep, because if they lost this case, as I say, you basically dilute the entirety of housing law and kind of result in a whole bunch of people across the country getting, much less support from their local authority. But it kind of goes back to this idea that the reason that Croydon gets itself into this mess, the reason that any council gets itself into this kind of mess where they don't have the resources, they don't have enough housing and so on, it's because nobody challenged them. It's because housing officers themselves just kind of swallowed it and said, okay, we'll just kind of sweep it under the carpet. And it's because members of the public, charities and whoever who sees this kind of thing happening, they see duties not being discharged lawfully, again just kind of get into this malaise where everyone shrugs and says, what can we do? The fact of the matter is, if you want to get someone housed and there's a duty to get them housed, then there is a lot of power within the law, within the duties contained within the law, to get people housed. And certainly my work in Bedford Borough, when I worked at Just Us and a few bits since then, I've seen that it doesn't actually take that much effort to get people housed. You just need to be willing to believe in the law and just hold the council accountable to it. That's kind of all you need. Even the kind of the detailed information you don't really need to know. You don't need to understand the ins and outs of housing law to do that. You just need to understand the basics and just kind of hold your ground. So when you have a senior housing officer, as probably happened in that initial Hillingdon case I talked about, basically saying, yeah, but we haven't got anything better, blah, blah, blah. You just need to say that's not good enough and say you've got a duty to do it, get to it. If that means completely changing the way your council funds different departments, then so be it. Now, that's obviously not going to probably result in that kind of level of change just by having one conversation. You probably do need to go down to the council to raise these kinds of issues. And on that point, you really need to make sure that your local councillors who are supposed to represent you understand the choices they're making, because they don't understand homelessness law. And I'm not criticising them for that. They don't, why would they? And they don't understand the level of injustice that happens. They'll probably see a little bit of it in their casework. But what happens a lot with councillors is when someone goes to a councillor, the councillor makes an inquiry to the housing team fixes it, and the councillor thinks all is okay. And the fact is, the other 20 people who didn't go to the councillor are still in exactly the same situation. So just to encourage you to get along to your local council meetings. It's far more effective than doing soup runs or kind of volunteering at a charity or even working at a charity in most cases, is to get down to your local council and just use your rights that you have as a citizen of this country, use the democratic process as it was designed to be used, and get these kinds of improvements for your local kind of neighbours and kind of local community.